Let's go to the topic on preference of wages. Article 110 of the Labor Code provides that in the event of bankruptcy or liquidation of employer's business, his workers shall enjoy first preference as regards their unpaid wages, and other monetary claims shall be paid in full before the claims of government and other creditors may be paid. However, contrary to our normal interpretation, the Supreme Court in DBP versus Secretary of Labor, November 28, 1999, ruled that this should be read in relation to the provisions of the Civil Code on concurrence and preference of credit. And it is not necessary that there is formal declaration of bankruptcy or judicial liquidation order for this rule to apply. So what do you mean by the interpretation that it must be read in harmony or in relation to the preference of credit under the Civil Code? In the case of Bank of the Philippines versus NLRC 242/62, the Supreme Court ruled that this preference of credit refers to Articles 2241 and 2242 of the Civil Code. For instance, in Article 2241, the payment of wages is only number 6 in the enumeration before the payment of other claims. And when it comes to Article 2242, it is only number 3 in terms of priority. So therefore, this Article 110, in case of bankruptcy or liquidation proceeding, even without order or order of the court, the payment of wages and other claims of workers is not given priority or should not be paid first. So that is the interpretation of the Supreme Court. So if there is an unpaid tax due to the government or mortgages due to banks or lending institution, then they will be paid first based on the preference of credit as provided in those articles. Because in the same case, the Supreme Court mentioned that the right of first preference as regards unpaid wages, which is recognized by Article 110, does not constitute a lien on the property of the insolvent debtor in favor of the workers. It is but a preference of credit in their favor, a preference in application. So that rule is already settled. So if there is any question on that matter, you know who will be paid first. That is the rule on preference of wages. Let's go to an instance prior to declaration of bankruptcy of the employer. The employer under your corporation law may resort to receivership or rehabilitation proceeding to save the company. So in this case, what will be the rule if there is a pending claim of workers? You have the landmark case of Alimar Sibal and Sons Incorporated versus NLRC, January 19, 2000. According to the Supreme Court, all claims, including workers' claim, shall be suspended. So all payments will now be coursed through the receivership committee, who is tasked by the court to pay all the indebtedness of the corporation, including workers' claim. Because in the case of Chanco and Salvacion, Jenny Manigo versus Unified Sales Warehouse Club Incorporated and Jimmy Gao, December 4, 2009, the claim of workers is pecuniary in nature, so it should be a money claim, so therefore it will be suspended. It doesn't mean that the workers will not be paid, because the management committee may be able to collect or to rehabilitate the company and pay the labor claims. So at the termination of rehabilitation proceedings or receivership, then the workers' claim can now be pursued against the company. Okay, so remember, the rule is very clear. Upon the creation of management committee or appointment of a rehabilitation receiver, all claims of action shall be suspended. No exception in favor of labor claims is mentioned by law. So everyone, all claims suspended. The purpose of which is to give chance to the corporation to rehabilitate. So once the petition for rehabilitation proceeding or has been terminated, then the stay order shall not be effective anymore. So that's how we go about workers' claim when it comes to receivership. So in the case of Agripino versus Molina, Agripino Molina versus Pacific Plans, August 15, 2011, the Supreme Court even ruled that even execution of judgment in favor of the worker should be suspended pending the termination of the rehabilitation proceeding. So it's either it is still a claim or there is already a judgment to be executed. All the same, they will be suspended. I think there will be no other questions relating to that matter. So the rule when it comes to rehabilitation, suspension of claims. And when it comes to preference of wages, it must be interpreted in harmony with the Civil Code provisions on preference of wages. Let's go to the next topic on the appearance of non-lawyer in labor case. Article 222 of the Labor Code provides that non-lawyers may appear before the Commission or Labor Arbiter only if they represent themselves or if they represent their organization or members thereof. However, we have to take note of the NLRC Rules of Procedure. Under Section 6, Paragraph B, Rule 3, it provides a non-lawyer may appear in any of the proceedings before the Labor Arbiter or Commission only in the following conditions: if he or she represents herself or himself as a party to the case. Second, he or she represents a legitimate labor organization as defined under 212 and 242 of the Labor Code as amended, which is a party to the case, provided that he or she represents the Commission or Labor Arbiter during mandatory conference or initial hearing. During the hearing, you should bring a certification from the Bureau of Labor Relations or Regional Office Department of the Labor and Employment or DOLE, attesting that the organization he or she represents is duly registered and listed in the roster of legitimate labor organization. A verified certification issued by Secretary and attested to by the President of the said organization that he or she is authorized to represent the labor organization in the said case. And finally, a copy of the resolution of Board of Directors of the said organization granting him such authority. So in that instance where you represent a labor organization, you should have with you the following documents that were already mentioned. 3 documents. if you represent, or if he or she represents a member or members of legitimate labor organization that is existing within the employer's establishment who are parties to the case, the following must be complied also. There is a verified certification attesting that he is authorized by such member or members to represent them in the case. A verified certification issued by Secretary and attested to by the President of the said organization stating that the person or person is representing the members of the organization. And another, that he or she is duly accredited member for purposes of representation. In addition to those mentioned, a non-lawyer must be an accredited member of any legal aid recognized by the Department of Justice or the Integrated Bar of the Philippines. Also, if the person appearing is the owner or president of the corporation or establishment of which is a party to the case, provided that he has verified certification attesting that he is authorized to represent the corporation, a copy of the board director's resolution of the said corporation granting him such authority. So, non-lawyers who appear without complying the above requirements shall not be recognized in any proceeding before the labor arbiter or the commission. Can you file your entry of appearance orally or in writing? The appearances of non-lawyers may be filed orally or in writing. In both cases, the complete name and address of the counsel or authorized representative shall be made of record, and adverse party of this case shall be properly notified. So those are the instances when non-lawyers may appear before the labor arbiter and the commission. So the question would be most likely just the requisites, whether you are representing a member of the organization or labor organization or members therein, or you represent the labor organization itself, or if you are the owner of the company of which is a respondent in the case. So you know already what are the requirements. There must be supporting documents only for purposes of appearance, especially in the recent procedure of the labor arbiter where there is what we call the conciliation proceeding or the Senate. So you don't need a counsel by then, and besides, counsels are not required in mediation proceeding. So just bring all those documents with you. But when it comes to making opposition paper, you must be represented by a lawyer.